Good afternoon, everybody. Good afternoon. My name is John Moy. I'm the Senior Director of Policy here at the Urban League of Greater Atlanta. And on behalf of President Johnson, welcome to the Urban League Policy Council. We welcome you today at our convening regarding a critical dialogue at a pivotal moment in our nation's history. We gather not only to reflect, but to reckon with the evolving role of the United States Supreme Court in shaping the lived realities of Black Americans, particularly in the realms of diversity, equity, and inclusion, and access to higher education, and importantly, the fundamental right to vote. We are honored to be joined by attorney Debo Adegbile, Esquire, whose legal acumen and unwavering commitment to civil rights have left an indelible mark on American jurisprudence. As former acting president of the NAACP Legal Defense and Educational Fund, Debo has stood at the forefront of landmark litigation, including his powerful advocacy before the Supreme Court in Shelby County v. Holder, a case whose consequences continue to reverberate through our democracy today. Today, Debo will guide us through an incisive analysis of recent Supreme Court rulings and their implications for racial equity, educational opportunity, and voting access. His insights will help us understand not only what has changed, but what must be done to protect and advance the rights of our communities. And secondly, I would like to introduce to you my co-moderator, R. Gary Spencer, who is a distinguished litigator with the NAACP Legal Defense Fund, where he has championed justice through strategic litigation and policy advocacy. With a career rooted in civil rights law, Mr. Spencer brings both depth and clarity to the complex legal terrain we'll be navigating today. And so with that, Attorney Debo, thank you so much for joining us. It is such an honor to be with you today. And welcome, Gary.
Thank you so much for inviting me to be in dialogue with you, and great to be here with you and Gary and with the whole Urban League of Atlanta. I so respect the work of the organization and organizations, Gary. Certainly yours is yours as well as an alum. So really looking forward to the conversation. And as John has said, it's a moment to be in these dialogues.
Can before we begin, can you just, first of all, I just wanted to share with the listening audience what a complete honor it is to be with you all, with you today, because among all of your notable achievements, one that certainly stands out is that you actually argued before the Supreme Court in Shelby v. Holder. And we can count on, I guess, a handful of Black lawyers who have ever actually argued before the court of something that huge. So before we start with the questioning, the court right now, in terms of, we've been looking at some of these court rulings and sort of scratching our heads. So, from your perspective, where is it, this Roberts Court, and where are we going with some of these rulings?
So John, I appreciate that you start with the easy ones. Thank you. Thank you for that. So look, this is a very bracing time for civil rights and opportunity. And it's a time when looking to the Supreme Court alone will not deliver us and protect us. What we have seen is a series of actions, of rulings, of litigation that really attack the foundations of opportunity, of democracy, of pathways for intergenerational progress, of core civil rights precedents, and of key civil liberties and civil rights protections. And so it's a very bracing moment. Nobody can shrink from that. The trend line has not been a good one for civil rights from the Roberts Court. And it doesn't mean that every case is a loss, but it means every case is a moment when you're sort of holding your breath and bracing yourself to see are the hands on the clock going to turn backwards again. And so when you're looking at Supreme Court litigation, you have to be clear-eyed. It's an exercise in trying to figure out, how can I count to five, right? Every Supreme Court advocate has the objective of trying to see, can they get 5 votes so they can carry the day? And when you look at this court and you think about the civil rights rulings and jurisprudence of the sitting justices, it's a very difficult exercise in most civil rights cases to think about how you have a reasonable pathway to get to five. That doesn't mean that you don't engage in the fight and that you don't focus on the best available arguments. It just means that it's a moment where, on balance, it's more likely that the ruling is going to be unfavorable from a civil rights perspective than favorable, and we have to be clear-eyed about that.
Good deal. Can you talk about right now the composition of the court? I know that Justice Sotomayor has sort of been out publicly talking about her concerns, but are there any bright spots right now in terms of the justices? I mean, I know we here at the Urban League, we're very interested. Obviously, Sotomayor and Justice Kagan, Jackson, and I'm missing one more justice of the 5-4. But are you where are they right now in terms of? I mean, are they gelling? Are they talking? Are they? How do you persuade some folks or?
Yeah, so my perspective on the court, I think one way to think about it is that there are three justices who are generally regarded as more progressive. You named them, Ketanji Brown Jackson, Justice Sotomayor, and Justice Kagan, and they, in most civil rights cases, tend to sort of dig into the roots and the history and the purposes of the civil rights statute, and they're completely unafraid and unabashed in speaking truth as they see it, in articulating the precedents and where they lead, and their voices are important, even though very often right now those are dissenting voices because they're not writing with the majority, and sometimes they will read their dissent from the bench. The point here, there's a tradition at the Supreme Court when a case is decided, the justices write their opinions and everybody can read their opinions. In certain cases where the court is particularly concerned or a justice is particularly exercised about the ruling, the justice will read their dissent on the day that the opinion is announced from the bench to give it a little bit extra emphasis and to direct the Supreme Court watching public to understand that this is one of particular import and a level of intensity in the feeling in the dissent. And we've seen that in some of the big cases. I believe that Justice Ginsburg may have read her dissent in Shelby County from the bench as one example. And so that's the progressive sort of set of justices. The rest of the justices are almost increasingly conservative in their jurisprudence. Justice Thomas, the son of Georgia, of course, is a very conservative justice, and he's a very difficult vote to get in most civil rights cases. Justice Alito is also a particularly conservative justice, and he's generally not a justice that in a civil rights case you're thinking will be persuadable if you're on the LDF or Urban League side, for example, of an issue. And then you have Gorsuch and Amy Coney Barrett and the Chief Justice, and all of them are conservative. Sometimes the Chief Justice might break in a particular way, but he, make no mistake, he's a very conservative jurist.
Yeah.
Several years ago, when the late Justice Stevens retired from the court, he had been on the court for over 34 years or around that time, 3 decades. And the comment he made was that in his time in the court, every justice that was nominated and confirmed to replace a predecessor was more conservative than the predecessor, regardless of which president was appointing the justice. The point being, I think he was making a point as somebody who had participated in and witnessed the history and lived the history of the court, that there was an unmistakable trend line in the court. And that was his observation as a retiring justice of the court. So it's a very conservative court, one of the most conservative courts in recent memory, frankly.
It is. It is. It is. I thought perhaps. Well, I won't go there. But I thought perhaps there were some opportunities to during the Biden administration to perhaps shape the composition of the court. But I want to ask you. First question is, you've argued before the Supreme Court in defense of Section 5 of the Voting Rights Act. How do you view the current threats to voting access, especially in states like here in Georgia?
Yeah, so voting, interestingly, has become an issue of such incredible, and it's always been an issue of
Yeah.
intensity, right? I'm
Yeah.
I'm speaking to the Urban League of Georgia, and so let us not kid ourselves. What I say is that when I think about the role of civil rights lawyers and folks that are fighting for civil rights, the way I think about it is that the Constitution gives to us very high promises: equal protection of the law, due process of law. And those are important constitutional promises to the people. But too often our experience has been marked by low practices. So on the one hand, we have the Constitution, high promises. On the other hand, we have the reality on the ground, low practices. And the way I view the role of a civil rights lawyer and civil rights advocates is to narrow the space between the high promises and the low practices, to work on the gap closing of lifting us up so that we can come closer to meeting the promises that we give to each other and that we have in the Constitution. And what we have seen is that there has been over many, many years a systematic effort to move in anti-democratic directions. That is to say, to close off pathways to participation rather than expanding opportunity and participation in the political process. There has been a very close study and observation that really there are two ways to win elections. One is by mobilizing people to your cause,
Right.
having a message that's popular and that can be disseminated and that people will get behind, and it's getting people to stand behind you, and it's democracy and victory through addition. But there's another tradition in America, a tradition very well known in Georgia, and that is that one way to win elections is by trying to close off the opportunity of your adversaries' supporters and to suppress the vote rather than expand participation. That's democracy through subtraction, not through addition. But the irony and the truth is that both are effective ways of winning elections. That's what we have to grapple with. You can win through either path. And increasingly, there have been too many people, including people in high places, as we know, who are prepared to try and win through subtraction, to try and close off and foreclose the possibility of people participating in elections, essentially not committing themselves to the democratic principles that we tell ourselves that we have stood for, and instead try and target and disenfranchise particular communities. And this pattern, which is a historic pattern, and no state knows it better than Georgia. From 100 years ago to today, no state knows it better than Georgia. And we have seen that this is a very real threat, but not only that it's a very real threat, but that the efforts of conducting elections by demobilization and by subtraction are not even, sort of hidden plans anymore. They're open and notorious of targeting communities, trying to passing legislation, with the express purpose of trying to close off demonstrated pathways of successfully mobilizing voters. And that's the legacy, John, that I think we're dealing, not just the
Yeah.
legacy, but that's the
Mhm.
reality today about what we're facing. And so we must face that with an intensity in the fight and not to yield, not to achieve some learned helplessness where we acquiesce or throw our hands up, but continue to push in the way that communities in Georgia, African American communities around the Deep South and around the country for a long time have been committed to, even when it's hardest, even when it's hardest to see that light at the end of the tunnel. There has been a persistence in fighting to close that gap that I spoke of earlier, and
Yes,
the intensity with which we embrace that obligation to do it not just for ourselves, but really for the country and for the next generations. That sits very heavily with me, and I know it sits heavily with your membership.
it does. Hey, Gary, would you like to chime in on that or?
Well, I mean, it is, um, Debo is absolutely correct. Unfortunately, Georgia has taken a path where it's easier to win if you can have voters kicked off the voting rolls, right? That's a path that it seems as though has been chosen by the leadership in Georgia. And so our job is to try to is to fight to reverse that trend, even if something is legal, doesn't make it right. And so there are lots of strong organizations in Georgia that continue to try to mobilize voters around the state to participate in a way that will make this democracy that will continue our democracy. Because some of us are concerned that once it's gone, it's not coming back.
That's right.
Um,
That's right. And for the listening audience, first of all, thank you all so much for joining us this afternoon. If you can put your questions certainly in the chat box, and I promise you we will get to them. Dave, I want to ask you about this, and looking at all the redistricting that's going on here, which is completely out of order. Normally, as you know, is done once every 10 years. And we've been fortunate to rely, quite frankly, on district courts. But can you talk about district courts and how are they helping us in terms of at least either holding the line or trying to slow some of this stuff down?
Yeah, so another important question, and I guess what I would say just to underscore the point you made about what's happening with the redistricting efforts around the country. Years ago, when Texas did this back in the Tom DeLay days, I think
Mm.
Texas was the first state to do what redistricting lawyers then called the redistricting. Essentially, redistricting follows the decennial census. And after we have the census numbers, because there's a constitutional requirement to have one person, one vote, it's required that when you have election districts that they're equipopulous, that roughly the same number of people are in each district, so that the weight of voters in each district is being given the same weight, the same consideration, right? If you had a district that had 100 voters and another district that had 10,000 voters, then 100 would have outsized power to choose a representative, right? Than the other district. And so one person, one vote requires that the lines be moved after the census to do that rebalancing. And that's when the redistricting comes. And historically, that's when we've done it. I think what we're seeing now, I think it's perhaps one of the best examples of the effort to win by subtraction and to win through the low practices, frankly, that I described also, right? When you're doing that, you're breaking with the tradition. You are so afraid that you won't carry the day by having a mobilization message that you are trying to restructure the architecture of democracy in the state to lock in a political advantage because you're afraid to conduct the election in the way that the state has drawn the districts and established. What you're trying to do is you're trying to build in a new advantage. And we have seen that some district courts, including some district courts in Georgia, have in certain redistricting cases, right? I don't think we've yet come to a round of litigation about these redistrictings that are foot in this cycle. But in the straightforward redistricting cases, the ones that followed the decennial census, there, at the margins, there have been some victories in litigation in Georgia and the like. Of course, litigation never stops in the district court. And so, there was a litigation that ordered that some districts be redrawn in Georgia because
Yes.
African Americans were having their votes diluted. And then there was the districts were redrawn. There was a substantial question about whether those redrawn districts answered the mail in terms of, providing the opportunity that plaintiffs were seeking. And I think there were a series of appeals that went from the district court up to the 11th Circuit Court of Appeals, the Federal Court of Appeals. And I think in the case that I'm aware of that many of the civil rights groups that my law firm and some others have participated in including some of your membership, I think those cases are pending right now with the 11th Circuit. But we have seen district courts in many cases apply the law as they find it, apply the Voting Rights Act, apply the principles, and call them like they see them. Not every court gets it right,
Right.
and not every voting challenge is meritorious. But we have seen in some circumstances that district courts have done well. We've also seen some very unusual rulings from district courts, including, courts that are sort of queuing up issues about whether voters have a right to bring cases under various parts of the Voting Rights Act, the core Section 2 provision of the Voting Rights Act, that they're sort of suggesting that there may not be standing for voters to bring cases under the act that was passed for purposes of enforcing the 15th Amendment and 14th Amendment in light of all of the Jim Crow practices of exclusion of African Americans and the like. So, not every court gets it right, but some of the district courts have hewed to the law, and the fight continues. No case of that kind stops at the district court. And so it's really a question of, what is the ultimate arbiter? And lots of these cases, and in cases I've litigated, I've sometimes found that our adversaries almost treat the district court litigation as just a speed bump because they're essentially trying to get the case to an appellate court and ultimately up the food chain where they think they may have a more hospitable audience. And sometimes that you can tell that when district judges catch a whiff of being treated with that disrespect and not having the case litigated seriously, they don't like it, but I've seen it happen.
Gotcha.
I'm sure gambling has views.
I want to ask you in terms of the Supreme Court in civil rights litigation. So, in your testimony, you criticized the court's decision, I believe, in Toomley, for raising barriers to civil rights litigation. What long-term impact do you foresee from these rulings?
So this is an important one, and this is it takes me back to being a first year in law school, right? When you learn that one of the classes you're going to have is civil procedure, that doesn't necessarily excite most young lawyers. You hear about the big constitutional questions, you hear about the criminal justice questions, you hear about the cases that you've known about, you hear about the First Amendment, and lots of times when people want to be a lawyer, they're sort of thinking about the great civil rights cases. They're thinking about those areas. But when you get to law school, there's a prescribed course of study. One of the first year classes that's very important is civil procedure. And when I was complaining, dealing with the excruciating root canal of civil procedure in my first year, a more knowledgeable lawyer explained to me that essentially, if you don't know how to manage and navigate the procedural rules of litigation, you don't get to the substantive issues. You don't get an opportunity to vindicate the principles that you want to go to court to vindicate. And so this wise lawyer said, civil procedure is the gateway for doing all that I hope to do in the law, and you better study it. So to say that I learned that lesson, there were these cases probably now almost a decade ago or more, that were cases that were in effect heightening the pleading standard. When I say that, what they were doing is they were making it so that plaintiffs that wanted to bring a case, a civil rights case, for example, had to have more facts on the front end to have their claim survive and get through to be able to get to discovery, to get to try and inquire to see, were there more facts? Were there hidden facts? What would the witnesses say? What did the documents say? Very often when you bring a case, you have an understanding that something is going on. There are parts that are visible, but there's what I call an asymmetry in information. The governmental entity, they know what's happening in the closed doors. They know what's happening in the meetings. They know what the motives are for the legislation. Even if it's a corporation, it's not all visible and known to the public and the plaintiffs. So there's what I call an information asymmetry. The way we solve that in litigation is that we get to have some discovery to learn what were the facts and motivations, what actually happened. But the Iqbal and Twombly case said that if you don't have a requisite number of facts, if you can't plead your claim out of the gate with the requisite degree of specificity, we're going to kick you out of court before you even get to discovery, before you get to ask for documents, and before you get to have depositions and the like. And so I worried that in civil rights cases, it was going to foreclose a number of meritorious cases because courts were going to kick these cases out before the plaintiff's lawyers had an opportunity to proceed. And I have to say it's been a little bit of a mixed bag in that district courts, coming back to your district court point, have been sort of careful to not over-interpret Iqbal and Twombly to knock out all cases that have a whiff of being meritorious or potentially so. That some courts have proceeded to allow cases to go forward. It used to be a very permissive standard when you pled a case and you would get an opportunity. Certainly Iqbal and Twombly elevated the standard that a lawyer needs to come into court with at the outset, but I don't think that it has, in practice, I don't think that it has fully foreclosed the opportunity to go forward in cases, though some judges have used it to kick cases that may, with time and discovery, have proven to be meritorious.
Thank you.
And John, let me add
please, Gary,
that
absolutely.
What happens is, so you have the pleading standard that Debo geniusly described, and you have other cases that have a different effect, right? Like, so you're looking for these facts, but courts have now said that when it comes to the legislator, there's a legislative privilege. So so you can't ask legislators what they were thinking about when they passed these laws. Now, some of these laws that affect voting, we have a pretty good idea about we know the effects, and based on the effects, we have a pretty good idea on who was thinking what. But again, you combine the heightened standard of some pleading requirements and the inability to ask legislators what were their motivations. You can see how these things can work together, not for our good, if you will. Now, the exception, of course, is the legislators are politicians, and politicians are given to talking, and so they can waive that privilege by at different meetings of their constituents. Well, we're going to do this, we're going to do that, but you can see how that all of this makes practicing civil rights law just difficult and uphill in many ways.
It completely raised the bar. I'm going to ask one more question, and then, actually, I want to open it up. I want to make sure this is interactive for the audience. So, Kennedy, are there any questions in the chat box that we could that you can pose? or that was raised? All right, so while she's doing it, I have one more question here. So how can legal advocates better use data to demonstrate systemic discrimination in courtrooms and policy debates?
So I'm sure Gary has views on this one. Maybe I'll throw out some thoughts and then we can be in dialogue about it. So there are different paths, there are different ways to prove discrimination in various contexts. There is the path in lots of contexts, including in a constitutional violation for an equal protection violation, where the court has ruled that you need to demonstrate that the intent, that the motive of the actor was discriminatory. You need to show in some way that the intention was to discriminate against somebody in order to carry the burden of a constitutional equal protection violation. There are some statutes, and there is a mode of proof under some important civil rights statutes where you can prove a case and illustrate that there was discrimination using a method of proof that is called disparate impact, meaning you're less focused on the intent showing and more focused on the fact that there was a policy or practice that's leading to a disparity that's having an adverse impact on a protected class, and that the defendant is choosing to use and adhere to that policy or practice, even though they might have ways to change their policy or practice and reduce the disparity. And so there is a mode under Title VII, for example, employment law, where you can prove a case through disparate impact. And in order to prove a disparate impact case, you need to show a disparity, and that's a lawyer way of saying, show me the data, show me what the impact is, show me what the pool of employees is and who you're hiring, what the pool of people applying for promotions are. Show me the data about how you're compensating people. What does that look like by gender or race? Is there an observable disparity in the data? How is that happening, right? And is it traceable to a particular thing that can be attacked? And if the employer can't explain it, if they're choosing not to use an available method that would reduce the disparity, they can be found liable for discrimination. The Fair Housing Act has the same mode of analysis as another statutory example. And redistricting that we've spoken a lot about today, there's a ton of data that underlies redistricting litigation, because one of the things you're always trying to prove is what are the opportunities for minority communities to elect candidates of their choosing in an election. That depends on the level of racially polarized voting, the extent to which voters will cross over and support voters that are not of their race, and where racially polarized voting is very high, where there's a reluctance based on experience and empirical data in election contests, where there is a reluctance of voters to cross over and support candidates who are not of their race. We say that that's a racially polarized context. And in those situations, if there's high racially polarized voting, if you don't have a very high concentration of minority voters or a majority of minority voters in the district, that prevalence of voters, that practice of voters not voting across racial lines will mean that no black candidate can win, no Latinx candidate can win, no Asian American candidate can win if the racially polarized voting is very high. And so that's why sometimes we think about what is the minority voter composition in a district. And this is about data. It's about regression analyses, looking at the election returns. And so underlying a lot of civil rights is the use of data. And the new frontier is going to be so much of the data and the data sets that we have in America build into it layers of discrimination and foreclosed opportunities. And so right now we have big data and we have AI. And so people are grabbing all sorts of data sets from all sorts of sources and then generating outcomes, sharing information, but nobody is really making a studied consideration about whether they are just building into these machine learning tools the discrimination that has existed over a long period of time, so
Wow.
that the data you're relying upon
Mm.
is essentially data that incorporates and builds on the exclusion that has characterized a lot of our experience in the United States. And that's one of the challenges of big data.
Yeah.
It's the challenge of garbage in, garbage out. If you are sucking in data that has bias built into it, the outputs that you will get will also have bias built into them.
Gary, you want to
And,
add to that?
well, I was going to say,
Yep.
it seems like many years ago, unfortunately, data did not convince the Supreme Court in litigation around the death penalty. The litigants proved that you are much more likely to be charged and convicted of a death penalty crime and receive the death penalty if the victim was white, rather than if the victim was black. That data was uncontroverted. Um, and by a 5-4 vote in the McCleskey case, the Supreme Court said, well, that data isn't enough. And we're pretty honest about saying that, well, if we did that, we wouldn't have a death penalty. Well, yeah.
Right.
But again, that was data that was used in a way that was not persuasive. So luckily, we still have some other ways, but in the death penalty frontier, as Brian Stevenson and the Equal Justice Initiative and other anti-death penalty advocates can tell you, we still have a lot of work to do there.
We do indeed. I want to ask you both. We were very excited here at the Urban League during the Biden administration when Kristen Clark was selected to head up the Civil Rights Division over at Justice. But it's been completely dismantled. Is that your understanding, Debo and Gary? And if and what effects? I mean, how will that reverberate in terms of the dismantling of that? Because where do we go?
Yeah.
Regarding
So there have been a lot of articles that have noted that a huge number of employees in the Department of Justice have left, either been relieved, demoted, and or resigned
yeah,
because they were not prepared to follow the policy directives of the new leadership that many of the career staffers thought was contrary to the statutory charge of the Civil Rights Division and the many important statutes and constitutional protections that they're charged with enforcing. And so, although the Civil Rights Division has been very active in some areas, very, very notably, higher ed institutions have been a very big focus of the Civil Rights Division under Hartmut Dillon, who is the current AAG. There is not a level of staffing in the Civil Rights Division right now to prosecute all of the cases, but they are focusing their efforts in certain areas, and they're very focused on attacking opportunity-based programs, the uses of DEI. We've seen memoranda from the Attorney General. We've seen things from the EEOC, all directed at closing off and trying to get people and entities to step away from opportunity-based pathways, interpreting the civil rights statutes in a way that in some cases I think extends beyond what the law tells us, but is really focused on the preferences of the administration. And that's playing out very actively right now across the country.
I want to ask you a personal question if I can. I remember uh, I began my career working in New York City, and I used to intern for a judge, New York City State Supreme Court, and it's the Macon B. Allen Black Bar Association in New York City. And in this particular year, I'm 21 years old, and Thurgood Marshall was the keynote speaker that year, and I'm a 21-year-old kid, and I'm sitting in the back of the room listening to. At the end, he was at the end of his career, but I was so mesmerized by Thurgood Marshall, and I had such an honor to at least shake his hand. And so for you, what was it? What was it? One thing that you said, Jesus, this is what I want to do, or what was that spark that got you into this work and doing the great work that you do?
So I think the thing that catalyzed me to do it is sort of taking a study as a young person of the extent to which those high promises were made but not followed, but that in the civil rights movement and effort, there was a concerted effort not to accept the status quo, but to push back and to hold the country to account for the injustice. And young people, as we all know, participated in that in many cases on the front lines. And taking some study of it as a young person, I think there was something in the possibility of fighting for something that was right when you see that it's wrong, and being able to be engaged in it and to, in some way, be a catalyst to work on that gap closing exercise that I described. There was something in that that spoke to me. And so I continued to try and learn about how it worked, who was involved in it, and how I could get involved. And I remember I started my career at a big law firm in New York. And when I left to go to LDF to litigate voting rights cases, I had worked with the late great Judge A. Leon Higginbotham.
Oh, wow.
And
Yep.
I had worked in redistricting litigation in Louisiana and in other states. Had represented the Congressional Black Caucus in a number of cases. And when I went to go do that work, I remember people sort of patting me on the shoulder and sort of thinking that it was nice that I was going to LDF to litigate these cases. But there was something clearly in their voice and in their mind that had them thinking that the fight that I was going to enter had passed, and that I was, going to do something that, while worthwhile, was not sort of a ripped from the headlines enterprise. And then came the 2000 election and Bush v. Gore.
Yes.
And every law school would soon have a voting rights professor. There would be new case books. People talk about Shelby County on the news. My daughter, as an undergraduate, had to read about that case as an undergraduate, and it really changed, in part because of those two roads: democracy through subtraction and addition, and the extent to which I think the Supreme Court has misunderstood the fragility of American democracy. They have misunderstood the fragility of American democracy. And you can point to any number of examples. But when I was asked to reflect on what the court got wrong in the Shelby County ruling, the core thing that I said is that the court misunderstood how fragile the democratic experiment is. And now we're all paying the price.
Indeed, indeed. I wanted to ask you something, and then I'm going to go to the questions in the box. And I know this might seem like minutia, but for those who have never, for many attorneys in their career, they will not have an opportunity to argue before the court. What is that experience like? You're standing there before 9 justices of the United States Supreme Court argue. I mean, what is that moment like? What was that like for you?
It was humbling, exhilarating, and terrifying all at one time. To be the designee of the Legal Defense Fund, to argue in these cases about a constitutional challenge to a core provision of the Voting Rights Act before a hostile court, a court that we knew was not likely to be on the side of upholding the constitutionality of the act. It was a very weighty responsibility, but it was also a culmination of why I wanted to be in the fight, why I wanted to use my studies and my efforts and my representations to try and speak truth to power in the best way I could about what the American experiment, what the American people, what African American people and the country need and deserve, and what their rights actually are. And so to have an opportunity to participate in that and to run a lap for justice was an extraordinary high. And obviously, in these cases, you want to win. Nobody argues these big cases to lose, but it's also important to record history. And I'm proud of the brief that LDF filed in those cases. I'm proud of the record and the lower court rulings where we won. And the court very clearly said that we had the weight of authority and the facts on our side. And I know that history will look back favorably on everything we said, including the point that our democracy is fragile and the core provision of the Voting Rights Act was doing important work in sustaining opportunity at the ballot box.
Thank you. Thank you.
And let me jump in
Sure.
real
Please,
fast
Gary.
because
Absolutely.
what Debo is not talking about, to his credit, is the sacrifices that he and his family made to get ready for that argument. I can tell you that we've had two litigators in the last 2 years appear for the Supreme Court, and in the fall, our director counsel, Janae Nelson, is appearing before the Supreme Court, and they are sacrificing all their personal time in addition to work time to get ready because they have to be the expert on behalf of democracy, right? It is you don't get a do-over, right? And so I know that Debo had to put family time to the side, other matters to the side, because when he says weighty, that really doesn't get it, right? He really had to just shut his life down in order to be the expert in Section 5 litigation and all of those things that go around Section 5 litigation. So I don't want him to downplay what he did, even though the court
Agreed.
was wrong. Uh,
Agreed. Agreed. Great. I certainly thank you. We all thank you for that. Deborah, we want to be
Let me
respectful
just
of
say,
your
because
time.
I think this is important. Obviously,
Please.
yeah, I think Gary's captured it. He's seen it up close and personal
Sure.
with his colleagues that are in it right now. But also, the other piece of it is when you're in a case like this, it's in part about what you're doing, but you're really standing there on behalf of so many people that have given so much, many of whom have given a lot more than I've been called to give in service of the Voting Rights Act, to bring it to us, to have it. We know that people laid their lives down in order to bring that bill and that legislation. And so it's not for the faint of heart. Being a Supreme Court advocate in a case of that consequence and moment, you have to dig in, you have to gird yourself. And Gary has, effectively spoken about what that looks like under the hood. But there is something that drives you, understanding that you are the person being called to take a lap for justice on behalf of so many who have given so much and continue to give so much. And so that's part of the fuel in your tank, I think, when you're going forward. That's part of the weight, is that you're standing for something that is much bigger than you, and your interests or your abilities. You're really standing about something that is about the march through history.
Every day I walk
and,
through. Yeah, please go ahead, Gary. Sure.
And I'm gonna say, John, I've seen in the chat that some people are concerned about what folks are doing and what they can do.
Yes, please.
And Dabo has really nailed it, right? There are roles for all of us to play. I working for LDF is the highlight of my life, right? Everybody can't be here. Before this, I took a different path. I was a criminal defense lawyer who represented people in Black Lives Matter, Occupy Atlanta, victims of police brutality. And so there are ways for all of us to contribute.
Agreed.
There
I
are
agree.
ways to make sure that your community understands how important it is to elect good people locally, right? It is important to make sure that those communities have resources and legal and not just legal competence, but legal advice that will help them move along because every case isn't a Supreme Court case, but those cases are important, right? There are
Right.
cases in the lower courts or even in state courts that are really important that folks need and really good advocates to speak on their behalf and communities need really good places where they can organize safely to do all those things. So the fight is not over by any stretch, even though sometimes it looks dark. But there's something that everybody who is in the chat, that everyone who is registered for this webinar can do, and it's really important to find that and to find that lane.
Listen, well said. That's the reason why I've been doing this work for so long. Debo, we only have 7 minutes. I know you're very busy. I just want to get to some of these questions. So I think one person, I think it's, I want to make sure that I get this right. I think it's Ms. Hill. Ms. Hill, I'm going to channel you if that's okay. There's a lot of frustration, certainly in the African American community, Debo, about whether or not this works for us anymore. It's just been a long, long haul, particularly for African Americans. Whether the democracy works for us, whether we should continue investing so much into this experiment. Where some folks question, quite frankly, the return on investment. So for those people who are discouraged right now, do we continue to fight for this democracy?
So everybody has to make their own judgment about what they think is in their own interest and what the best path is to be on. I take the point of frustration, and that we have, there's a lot to be disappointed about, and there are some patterns that seem unfortunately and shockingly never to get broken, and it's the same thing, different day. There are some folks that have the view that regardless of who's in charge and in the state capitol or in Washington, D.C., that not a lot changes. And certainly people are entitled to that view. I guess the way I look at it is that opting out and doing nothing probably isn't a path to having things improve. But I remain open to folks thinking about what the different levers are or what the targeted opportunity might be to hold somebody to account. One of the things that I've thought about very often, coming back to the framework of mobilization and demobilization, addition and subtraction, is that if people that don't participate in elections consistently participated in elections, if lots of the folks whose interests are not being represented could consistently participate, it might actually change what could be on the table in terms of what's being talked about in the legislatures and in the Congress, because there could be an opportunity to actually change the dynamic. And what happens is certain swaths of society, the moneyed interests, the propertied interests, certain interests control so much of the process that they set the dialogue and certain things don't get talked about at all. And it's possible to say that nothing matters and it doesn't matter and everything's the same. But, 543 votes or something in a Florida election may have changed the course of history. Does the war in Iraq happen if that election goes in a different way? What are the downstream consequences of that? Did Barack Obama getting elected and the healthcare bill passing, did that change some things in a real way? Now we see threats to that healthcare bill. President Trump serving his second term. You see who his cabinet officers are. You see what's happening in the agencies of the federal government. Is it really true that there's no difference in terms of who's sitting on the levers of power?
Yeah.
Is there really no difference for Black communities as between choices in various elections? I think that the full range of choices are not there, and I
Sure.
understand the frustration about all the things that don't get done. But just looking at what the experience has been, I think that sometimes that figuring out what lever you can push and push hard on it may be better than opting out altogether. And which is not to suggest that the people in the chat are calling to opt out altogether. And
Sure.
I welcome, to the extent that there are different paths or other mobilization or organizing efforts, I welcome that as well.
A last question. We have 3 minutes to go. What happens when the president defies a court order? I mean, I think Karen raised this issue about the National Guard, and so what happens when he defies this, the Supreme Court? I mean, what do we do in those instances when the president just flicks them off?
So I guess the first thing you need is that you need the Supreme Court to do the right thing, meaning you need the
Right.
Supreme Court to enforce the law and to impose some constraint and not to bow in toto to what's called the unitary executive and
Yes.
unbounded
Yes.
presidential power.
Yes.
That's important. I think we go into constitutional crisis if you have an order of the court and you have the president not adhering to the ruling of the court and ignoring it. I think that's nothing short of constitutional crisis. And while nobody can predict exactly what happens, I assume that the consequences of such things are not pretty pictures. That we really are in a crisis that threatens our democracy and our democratic system.
Yeah. All right. Well, listen. I just want to. It's 1:59. I want to thank you so much for your time. I want to thank you, Gary, and Debo. Listen, at some point, I know you're busy, but perhaps next year we can bring you back at the end of the next term of the session to see what the analysis is. But thank you for your service. Thank you, Gary, and I want to thank you, the listening audience, for taking time out of your busy schedule to be with us. On behalf of Nancy Flake Johnson, the President and CEO, and the Urban League of Greater Atlanta, we thank you so much, and we'll see you soon. Thank you all very much, and be well. Thank you.